Well, good morning, good afternoon, good evening, everybody. Welcome to our first session in our webinar series on responsible business in conflict-affected and high-risk areas. Thank you so much for joining us. This session, titled "Can Businesses Avoid Complicity in International Crimes?" will take a look at the role of businesses in conflict zones and whether they can truly operate without becoming entangled in grave human rights violations and/or international crimes. And my name's Lara Strangways. I'm the Head of Business and Human Rights at Global Rights Compliance and a Director at Beyond Human Rights Compliance, the business advisory arm. Today, we're privileged to hear from two leading experts on these issues. To guide us through the legal technicalities of complicity, I'm honoured to introduce Wayne Jordash KC, an internationally recognised expert in international criminal law and business and human rights, and the managing partner at Beyond Human Rights Compliance. Wayne has represented both states and individuals before international courts and tribunals, including the ICTY, ICC, and others, and has advised governments, corporations, and financial institutions on human rights due diligence, sanctions risks, and other corporate liability issues under international law. His extensive experience in accountability mechanisms and atrocity crimes hopefully makes him the perfect person to help us unpack today's question. I'm also honoured to introduce Eva Gerrits, who is a project lead in the Business Conflict and Human Rights Division at Dutch peace organisation PAX. She currently leads various parts of PAX's work on business and human rights, including business involvement in the occupied Palestinian territories. PAX were critical to persuading the Swedish public prosecutor to open a criminal investigation into the activities of Lundin Oil and its then executives Ian Lundin and Alex Schneider. Eva will outline some of the details of that case and reflect on how heightened human rights due diligence would have protected the victims in that case and potentially avoided the criminal trial. So before handing over to Wayne, I just want to give obviously a little bit of context to this series that the forefront of a lot of practitioners' minds at the moment is business operations in conflict-affected and high-risk areas, particularly because they present quite a unique and complex series of challenges. Beyond legal compliance, companies operating in these regions do have a heightened responsibility to prevent harm, mitigate risks, and ensure that their presence does not exacerbate human rights abuses or fuel conflict. Yet, as we're seeing in Myanmar, Sudan, Ukraine, to the occupied Palestinian territories, many businesses are continuing to fall short, failing to conduct meaningful human rights due diligence, and in some cases, becoming complicit in serious violations of human rights. So, as we will explore today, the consequences of corporate involvement in such crimes are becoming increasingly severe, with legal liability no longer limited to companies themselves, but often extended to individual executives. I really hope that this session will challenge us to think a little bit critically about the intersection of business and human rights and criminal liability, and think about how companies can truly avoid complicity in international crimes and how they can do that. So with that context, let's begin. Over to you, Wayne.
Thank you very much, Lara, and thank you everybody for attending. As Lara has mentioned, this is the first of a series of seminars designed to explore how businesses can work in conflict-affected and high-risk areas whilst respecting human rights. As you all know, there's been a proliferation of soft law and now, more recently, hard law on the way, in which there is a recognition that maintaining respect for human rights in conflict-affected and high-risk areas is particularly challenging. Heightened due diligence is on the tip of our tongues, and yet, do we really know much of what it is supposed to involve? We know, of course, that it's not just about situations of conventional armed conflict, but also military occupation, mass atrocities, and other situations of widespread violence. The likelihood of violence is the departure point. We know that. And we know from UNDP that there are various phases that heightened due diligence must involve. assessment of the conflict, 1, 2, assessment of the impact or likely impact of business activities on the conflict, 3, human rights risk assessments, 4, and this is the key, of course, designing business activities accordingly, acting, planning, implementing, monitoring, and evaluating business activities, taking into account the risks identified by the first 4 steps. But of course, the devil is in the detail. And that is what these seminars are about, exploring the basic steps that heightened due diligence must involve, starting at the beginning, exploring the basic law, and that's what today is going to be about, trying to understand how businesses can contribute to violations, what are the risks, including legal risks. And thereafter, the following seminars will try to dive more deeply into what is international humanitarian law, what is an occupation, and what are the risks working in an occupation, and thereafter looking at heightened due diligence and some of its component parts in different sectors, from agriculture to the garment industry, to private security, and so on and so forth. We are going to try in these seminars to fill in some of these gaps and have a discussion with you all to try to understand better what is required. So this is the first seminar. The next month's seminar will be on corporations and their international humanitarian law rights and obligations, and we'll be holding that with ICRC. And the third seminar, which I'm sure will be interesting to many of you, we will look at occupation through the lenses of businesses operating in occupied territories such as Palestine and Western Sahara. Please feel free to put into the chat any suggestions you might have as to what you would find useful for any future seminars. So let's begin today. I want to drill down a little into the first stage of human rights, heightened human rights due diligence, conflict analysis, and why it's important. As part of the conflict analysis, the business has to do various things. It has to explore various things. It has to explore the general context shaping the conflict, its causes, as well as the actors influencing it, and their interests in the conflict. Businesses need to be aware of the potential future causes of instability in the conflict, such as the political and economic situation in the regions where it operates, and so on and so forth. We'll come back to some of these in later seminars, but today what I want to focus in on is an assessment of the violence that is likely to represent the most compelling risk for businesses. That is a critical part of step 1. As you will appreciate, in situations of armed conflict or mass atrocities, individuals' rights and legal risks for businesses are no longer simply found in international human rights law. They are also found in international humanitarian law. They're also found in international criminal law. They're also, and this is often ignored by business, found in public international law, the law that regulates states against states. Moreover, and this is going to be a feature of these seminars, this type of analysis will tell businesses what kind of fact-finding methodology, what kind of investigations do you need to conduct in order to bottom out your risks. This is something which we are surprised at beyond is often ignored. The need for hard-nosed investigations, not just stakeholder dialogue, which is critical, not just human rights risks assessments of a general nature, but importing fact-finding of investigative work into your risk assessment because of the complexity of the situations, the complexity of conflicts, the complexity of the law that is applicable. You need often hard-nosed investigations, and that is routinely ignored. I'll come back to that during the course of this seminar because it's critical to understand risk. So first of all, does IHL apply to businesses? Well, international humanitarian law is a set of rules that seeks to regulate warfare. It seeks to protect individuals that are not taking part in hostilities, their rights, their property, from the conflict and its consequences. Civilians are protected, wounded fighters are protected, prisoners are protected. Now, there's a tricky question here as to whether international humanitarian law directly applies to businesses. That's going to be discussed at a later seminar, and it's our view it probably doesn't create direct obligations. However, let's focus in on international criminal law. This is the set of international rules that operate in order to prosecute actors responsible for violations of international law in conflict situations and outside of conflict situations. International criminal law labels specific international human rights and international humanitarian law violations as international crimes. Genocide, crimes against humanity, and war crimes. This is what we are going to be talking about today. And their commission, their occurrence, obliges states to prosecute them at the national level or at the international level. Thus, if you're a corporate actor, whether a corporation itself or individuals within the corporation, if you contribute to violations of international human rights or international humanitarian law, you may become liable for violations of international criminal law and find yourself prosecuted at the national level. There is no dispute that corporations and individuals can face liability for international criminal law violations. And there's no dispute also that business actors can be prosecuted. This is true at Nuremberg, where businessmen were prosecuted. It's true at the International Criminal Court, where executives of a corporation, a postal corporation, and radio broadcaster were prosecuted. It's true at the International Criminal Tribunal for the former Yugoslavia and International Criminal Tribunal for Rwanda, where businessmen and company executives were prosecuted. And I'll come back to a couple of those cases shortly. So a business cannot consider that its civilian character or that of its co-contractors, subcontractors, is sufficient to distance its activities from the crimes and protect it from international criminal liability. It is without a shadow of a doubt in the best interests of businesses, and Eva will touch on this in relation to the London case shortly, to ensure that they comply with international humanitarian law, international human rights law. Acting to respect these laws will ensure against international criminal law liability. So let's just drill down a bit further into when international humanitarian law might lead to international criminal law liability. International humanitarian law applies to situations of armed conflict. There are two kinds of armed conflicts: one, international armed conflicts, and two, non-international armed conflicts. International armed conflicts also include occupation, and I'll talk about that shortly. When does an international armed conflict occur? When one or more states use armed force against another state, regardless of the reason behind the force, regardless of the intensity or duration of the force, regardless of the number of personnel involved, or casualties arising. As long as there is use of force by one state on the territory of another without the consent of the latter, there is an international armed conflict, and all four Geneva Conventions and Additional Protocol 1 to the Geneva Conventions, an array of customary international law, which is not contained as such in the conventions, applies to that situation and creates rights and obligations for actors involving or acting within the international armed conflict. Occupation is a form of international armed conflict. A territory is considered occupied when it's placed under the authority of a hostile army. Important to note, occupation law is evolving. Occupation does not require the continued physical presence of the occupying power's military forces on the territory. it is sufficient that the occupier is capable of enforcing their authority, including by making its physical presence felt within a reasonable time. You will have heard of the International Court of Justice. You will have heard about their judgment in 2024 in relation to Gaza. There was no military presence of Israel in Gaza. Nonetheless, the court considered that Israel was in occupation of Gaza. Why? Because it was capable of exercising authority over the Gaza Strip, including controlling the land, sea, and air borders, and restricting the movement of people and goods inside the Gazan territory. This even more so since the 7th of October 2023, according to the International Court of Justice. So occupation has become more complicated, and it also has become more demanding on the occupier. Situations of occupation are regulated under international humanitarian law, and this has consequences under international criminal law. Occupation brings into play Geneva Convention 4 and the relevant rules of the Hague regulations. And these demand of the occupier a range of obligations, such as that the occupation must be temporary, that the occupying power must protect the interests of the occupied population, and manage the natural resources of the occupied territory, not treat the territory as if it's its own territory. That question of an illegal occupation is also a critical question, and I'll come back to that shortly. But before I do, let me touch quickly on non-international armed conflicts. Under Article 3, common to the Geneva Conventions, non-international armed conflicts are armed conflicts in which one or more non-state armed groups are involved. Depending upon the situation, hostilities may occur between government armed forces and non-state armed groups, or only between the groups of non-state actors. Important distinction: non-international armed conflict should not be mistaken for situations of internal disturbances and tensions such as riots, isolated and sporadic acts of violence, or other acts of a similar nature. The hostilities must, in a non-international armed conflict, reach a certain level of intensity, and those involved must have a certain level of organization. Things can get very complicated, of course, when you have a mixture of activities which are more clearly classified as riots or protests, and those where the parties evolve into possessing organized armed forces. No reason why you cannot have these things happening at the same time, and there's no reason why you cannot have an international armed conflict occurring at the same time as a non-international armed conflict. In fact, this may well be the case in Myanmar since the coup of 2021. The military junta has been facing ethnic armed groups in high-intensity hostilities. For sure, armed groups who are sufficiently organized, but also facing civilian groups of individuals fighting in sporadic and disorganized manner, which might be more akin to internal or to riots or protests. So one thing I wanted to touch on, and I made mention of this, illegal occupation. One of the questions for businesses is, and it may be, in fact, the starting point is when looking at conflict, is to ask the question whether the use of force by the state in an international armed conflict is a lawful use of force, because businesses not only have to ensure that they don't contribute to international criminal law violations, they also have to make sure that they don't exacerbate illegality. What does that mean? Well, under the UN Guiding Principles, a business operating in the context of an unlawful conflict as well as respecting human rights and international humanitarian law, should assess and avoid or mitigate its connection to the war efforts of the aggressor country to ensure that it doesn't, as I mentioned just a moment ago, exacerbate the situation. The question of legality, therefore, is an essential question. It's a question that the International Court of Justice looked at in relation to the Israeli settlements only recently in 2024, and I referred to that judgment a moment ago. And to ask itself the question, is Israel in occupation of Palestinian land? But then thereafter, is that occupation illegal? Has it become illegal because, for example, Israel is using a disproportionate use of force or force in violation of the UN Charter? And is it violating international human rights law to such an extent that it's denying Palestinians the right to self-determination, which then informs both the illegality of the occupation, but in due course, the nature and scope of the war crimes? I can come back to that on question and answers if anyone is particularly interested in that. Now, turning to how do businesses contribute to international crimes? 3 critical questions. Are international crimes occurring? Are the business activities contributing to them, and to what degree? And who from the business is aware of the contributions, and what steps, if any, are taken to mitigate? Think acts, think contributions, think mental state. These are the building blocks of a case against either a corporation or against individuals from that corporation. We don't have time to dig into each of the definitions, but we can disclose to you the slides where we've just listed the basic definitions of genocide, of crimes against humanity, and of war crimes. And what you're always talking about with international crimes are, what are the acts? What is the context? What is the mental state required to make that contribution more than just a physical contribution, but in fact an international crime? So with genocide, you have 5 critical acts. The context is a pattern of similar conduct, and the intent, as you will have heard, is the special intent. We're very short of time, so I'm running through this very quickly, but businesses will have heard of the special intent, no doubt, and maybe feel somewhat reassured that it's very difficult to prove that special intent. However, businesses should think about complicity to commit genocide. And in fact, complicity, as I'll come to shortly, is in fact the real danger often for businesses. It's assisting in contributing to international crimes. Complicity to commit genocide does not require the special intent of genocide. It requires that the assister is engaged in actions whose foreseeable results may have contributed to genocide. They do not need to have the personal intent to commit genocide. Bagaragaza from Rwanda was the head of the tea industry who found himself in similar difficulties. Handing over, under some threat, it has to be said, assets from the factories, trucks, money from his house, not intending to commit genocide himself, but knowing that his assistance would facilitate the genocide. Guilty of complicity in genocide. Crimes against humanity, similarly, a range of acts, which you'll see, I think, on slide 12. Context, widespread or systematic attack directed against a civilian population. And a mental state, which accords with the individual acts such as murder, and knowledge that that conduct was part of or intended the conduct to be part of the systematic or widespread attack against the civilian population. And war crimes, just moving swiftly on, same construction, individual acts, such as the four that you'll see on slide 14. They can be basically divided into four categories: crimes against individuals, including their rights and dignity; attacks against protected objects; those attacks which are in violation of principles which are the core of international humanitarian law. So precaution, that all feasible precautions must be taken to protect civilians, that attacks must be proportionate, and so on. And then number four, the use of internationally prohibited weapons. So you're looking in the first place, what kind of acts? Crimes against individuals, willful killings, torture, inhumane treatment, sexual violence. Attacks against protected objects might be attacks against education, so healthcare, violations of principles such as proportionality, attacking military targets, knowing that the effect on the civilian population will be disproportionate to the military advantage obtained, and the use of internationally prohibited weapons such as cluster munitions or chemical weapons. So acts, context, and mental state. And let me say something about mental state, and this is where it gets very complicated. The most important mental state is often the mental state of the specific act. But it's a mistake to think, as Bagaragaza from the Rwandan tribunal found, that it's all about criminal intent to commit the crimes. It's not a defense for a business actor to say, but all I cared about was making profit. I didn't intend the crimes. I didn't even want those crimes to occur. That's not sufficient. That will not provide legal defense. What is important is awareness, which may turn to intent to either commit the crimes or intent to assist the crimes. And I'm going to just spend a little bit of time in the last 7 minutes on that, because it's really an important issue. Now, there are obviously two types of two types of liability we need to be concerned with: corporate liability, that is national jurisdictions who hold corporations responsible for involvement in international crimes, and then on the other side there's the type of international criminal law against individuals themselves. And what you'll see in relation to both is that the contribution and the mental state are the critical factors. With corporate liability in national jurisdictions, such as in the French system, the company is liable for the acts and intent of its organs and personnel. So the acts of the personnel are imputed to the corporation, provided that the offence was committed in the course of their duties or intended to benefit the corporation. Interestingly, a company may avoid liability by demonstrating that they put in place effective due diligence programs. A couple of important points which relate to what I've just said about mental state. Liability can arise through direct participation or accomplice liability, that is assisting the crime, not through direct only. An organ or personnel must have intended to commit the crime. However, intent can be understood as an offender not only being aware of the considerable possibility that a certain consequence may result from his action, but also of approving of or reconciling himself to the possible occurrence of that result. In other words, in short, intent is not just about what your purpose is. Intent is also what you are aware will occur in the ordinary course of events. That is the form of intent which runs through most of international criminal law. The best example I can give of that, cut through some of this, is the plane example I learned in my early days at law school. I place a bomb on a plane because I want to kill one person. I intend to kill that one person. I don't want to kill the other people, but I know that it's virtually certain if I bomb that plane, I will kill everybody on that plane. That is intent according to international criminal law. You intend to kill the one and you intend to kill the others. Why? Because it's virtually certain you will kill the others, and you were aware that it was virtually certain that you would kill the others. Corporate liability at the national level has variations of that type of intent. It's much less than purpose. It's much more about awareness. And ditto with individual liability against individuals. International criminal law has adopted and refined various modes of liability, which consists of physical and mental elements, whether it's ordering, planning, aiding and abetting. International criminal law violations occur as part of plans, and individuals contribute to those plans, and they can contribute to them in a significant or substantial way and become part of the mastermind of those plans. Or, as is the case with many businesses, contribution is less than significant, but still important, and you may find yourself therefore prosecuted for complicity, aiding and abetting. Aiding and abetting is the most relevant mode of liability for individuals in a business context. There are two forms of, well, actually three forms of aiding and abetting. Very strict form at the International Criminal Court, where you need to show that the individual, the assister, had the purpose of facilitating the crime. Less strict at the International Criminal Court for Rwanda and former Yugoslavia, which requires mere knowledge that the acts performed by the aider and abetter would assist in the commission of the specific crime by the principal. Even less strict are many national approaches, which require that essentially the accomplice knew that the direct perpetrators would commit crimes, and nonetheless, the individual went along and provided that assistance. And Lafarge may be a good example of that, and London's may be a good example of that, and I'll leave Eva to speak about that. So I hope I've just given you a very, very quick tour of the important elements of international crimes, but also the important elements of accomplice liability and liability more generally. It's a very quick tour, and I couldn't hope to touch on everything. These are really complicated issues, which require, at the end of the day, the involvement of experts, international criminal law experts, to bottom out what is the applicable law, how can business activity contribute to it, and how, according to heightened due diligence, can structures be put in place internally within the business to ensure that any contribution is minimized and any harm is mitigated. Mitigation and minimizing are key to avoiding legal liability, especially when, and I go back to this and I don't apologize for it, especially when what we're talking about is contribution with awareness in many instances amounting to sufficient to create real legal risk. I'll come back to this in the Q&A, but let me hand over now to Eva to talk about the London case and how some of these principles are relevant to that case.
Thank you very much. I'm audible, right? So yeah, thank you so much for the introduction, also the opportunity to participate in the discussion on what is, yeah, I think a very important topic. So I know there's little time and a lot to cover on what is a very significant case, very big. So I'll start with a bit of background on the history of the case and Pax's involvement, and then I'll go to well, what happened in Sudan, so the facts that are actually now tried. And then I'll delve deeper into the trial, so specifically the indictment and the issue of complicity that Wayne just talked about. As a disclaimer, I'm not a lawyer, and definitely not a Swedish lawyer, but I'll try my best to discuss the legal details of the case. Yeah, so in 2010, Pax, as chair of the European Coalition on Oil in Sudan, published a report called Unpaid Debt. So this report, we described the involvement of international oil companies, mostly the Swedish oil company Lundin, and also its consortium partners, OMV from Austria and Petronas from Malaysia, their involvement in the Sudanese oil wars in the late 1990s and the early 2000s, and in the war crimes committed during this period. The report called upon the home governments of these companies to investigate the activities of their companies and ensure that they would be held accountable. So the publication of the report directly led the Swedish public prosecutor to open a criminal investigation into the links between the reported crimes and Sweden. So in 2021, after 10 years of investigation, the indictment was published. Ian Lundin and Alexandre Schneider, senior executives of Lundin, and at the time of the indictment, they were respectively chairman and CEO, were indicted for complicity in crimes against the law of nations, crimes against international law. The trial started 2 years later, in September 2023. The prosecutor has presented 80,000 pages of evidence, and the trial is set to last until the first quarter of 2026, which will make it into the longest court case in Sweden ever. A little bit of background on Lundin in Sudan. So in 1997, Lundin signed a contract with the government of Sudan for the exploitation of oil in a concession area called Block 5A. At that time of the signing of the contract, Sudan was torn apart by a civil war that had started in 1983 between the government and allied militias and a variety of armed rebel groups, mostly from the southern part of the country, which is now South Sudan. Block 5A is an area of around 30,000 square kilometers, was located at that time, and that's very important, in an area that was not under full government control at the time the contract was signed. So, and it was also a relatively peaceful area within the context. However, the prospect of oil production gave the area a strategic significance, a set of vicious war there, which was essentially about the government trying to secure control over the oil areas to ensure that oil exploitation could take place. So what actually happened? During the period 1999-2003, that's the period that Lundin was, that Lundin was active there, from 1997 onwards, the Sudanese military and allied militia groups carried out a large number of offensive military operations and attacks in and near Block 5A in order to take control of certain areas that were then under the control of rebel groups. So the manner in which the government and its allied militias did this involved systematic attacks on civilians and civilian property. The attacks were indiscriminate and disproportional and in clear violation of international humanitarian law, and this is also what is described in the indictment. So the government used aerial bombardments, gunship helicopters, and ground troops to kill and displace people from their lands and destroy or loot their properties and their means of livelihood. This lasted until 2003, when Lundin left the area. An estimated 12,000 people were killed or died from hunger, exhaustion, or war-related diseases, and 160,000 people were forcibly displaced. The area was utterly destroyed, devastated, and has actually still not recovered until today, and none of the victims have ever seen any form of remedy. So the government used a systematic and established method of warfare that had been used in other parts of Sudan before, and that was, and that's also important, very well documented at that time. So from the early 1990s, national and international human rights organizations had started issuing periodic reports about human rights abuses in Sudan. By 1996, the government had been condemned for human rights violations by the UN General Assembly, the UN Commission for Human Rights, the African Commission on Human and People's Rights. In 1997, so the year that Lundin signed the contract, the Sudan National Security Council resolved that all military resources should be made available to control the oil fields. Already, actually, as early as 1983, the government had employed militias from the north to drive away local communities from the oil-rich areas in the south. They had already cleansed actually oil blocks 1, 2, and 4, the big oil blocks north of Block 5A. And from 1998 onwards, numerous human rights organizations, big humanitarian organizations, UN special rapporteurs reported on the massive humanitarian catastrophe and the gross human rights abuses taking place in Block 5A, which involved indiscriminate killings, arson, looting, a massive amount of rape, enslavement, underage recruiting, and torture. So then coming to, or fast forwarding to the indictment, Ian Lundin and Alexandre Schneider were senior executives at that time. They are accused of promoting this military campaign and in this way aiding and abetting the war crimes that were inherent to the military campaign. So according to the prosecutor, the military offensives were responses to Lundin's work plans and security requests, over which the accused, so the two executives, had a key influence through their executive positions in the company. The indictment itself zooms in on 11 specific requests for security by Lundin or the executives, and 5 protracted military offensives by government forces, and tries to show the connections. So on these occasions, the defendants or the accused requested the government of Sudan to secure and create the conditions for the company's operations in Block 5A. For example, to construct roads or bridge, to clear operational areas, or to provide security to the operations. So they requested this, or they informed the government of the need to do this. They allegedly knew, or were at the very least indifferent to the fact that this entailed that the government would need to carry out offensive military operations in the area, and that this method of warfare included systematic attacks on civilians. Well, as I said, the prosecutor has presented 80,000 pages of evidence, including a lot of internal memos, internal security reports, but also letters to the government and agreements signed with the government. And the prosecutor argues that this evidence shows that, well, the accused held key executive positions in the company through which they had influence on what was going on in Sudan and on the government of Sudan, which is the perpetrator of the crimes. They requested the government on multiple occasions to take care of security, repeatedly asked for strengthened, increased security. The accused received continuous information about the security situation, and the accused allegedly knew that the military was attacking civilians, that the Air Force had bombed a village, that there was massive civilian displacement going on. They were informed that the military's presence in and around the block was intended to provide security for the company's operations, that the road and the bridge that they were building in agreement with the government, that they were intended for military use to in turn serve the interests of the company. For example, a quote from an internal memo is saying, "The army are requesting a road to Nialdu before they can put security in place." They also on several occasions pointed out to the government that the rebel forces in the area were a threat to the company's operations, and they encouraged the Sudanese military's alliance with militia forces against the rebel forces. So in one meeting, Alexandre Schneider expressed his appreciation of the way in which the government was creating the conditions needed for the company's operations, thereby, according to the prosecutor, giving his approval to this use of, or to the use of this approach, also in the future. So at the moment, the court proceedings are going on, and the prosecutor is also going into other issues described in the unpicked debt report, like how the airstrip that the company built and partly operated was used by the military, including for their Antonov bombers that were used to bomb villages in the area. but also how the company provided other forms of logistical assistance to the government and the allied militias. It's also discussed how through the construction of the road and of one particular bridge, the geographical reach of military forces was expanded into a before quite secluded area, which endangered the communities that were until then protected by attacks from northern armed forces, protected by these natural barriers that were now crossed. So next to the two executives, the company itself, which is now named Orun Energy, is also indicted for having profited from the crimes. The prosecutor has demanded a forfeiture of about 210 million euros, as well as a fine. So on the question of intent, so to prove complicity, the prosecutor needs to prove, well, not only the contribution, as Wayne explained, but also the mental element, the intent, the knowledge and intent. So there are three levels of intent in Swedish law. There's direct intent, there's indirect intent, and then there's a third one, which is called indifference intent or reckless intent. This means that the perpetrator is aware of the risk, but is indifferent to it. So he's indifferent to the risk as well as to the realization of the risk. And it also does not require a substantial contribution. It can be also a smaller contribution. So the prosecutor in this case is going for this third level of intent, which is a lower level of intent than is handled in international tribunals and the ICC, I believe. In the indictment, he states what constitutes complicity in a criminal sense is that they made these demands despite understanding, or in any case, being indifferent to the military and the militia carrying out the war in a way that was forbidden according to international humanitarian law. Then the defense. So over the past few weeks, actually, Ian Lundin was heard in court, and this week the hearing of Alexander Schneider has started. The defense lawyers actually challenge each and every component of the indictment. So, yeah, for example, they claim that there was complex historic intertribal fighting in South Sudan, but not like a war, and definitely not related to oil operations. That the government did not commit war crimes, so that the actual crimes that are described in the indictment did not take place. The government did not control the local armed militias, that there were many reasons for the displacement of civilians, not only violent attacks, that there's no connection between Lundin's operations and warfare, and if the attacks took place, it did not have to do anything with actions by Lundin. The suspects did not ask for any military offensives. The suspects did not have decisive influence over security matters in the company. They actually denied that they did anything or knew anything of what was going on, in their own company. Sorry. The suspects never had the intention to cause or contribute to crimes. NGO reporting at the time of war crimes was unverified and was part of a propaganda war by the Southern rebel movement. The international community was supportive of foreign enterprise in Sudan, and the company had an actually beneficial impact on the civilian population. So in April, the court will start hearing expert witnesses. The South Sudanese witnesses have testified over the course of last year, both in Sweden as well as in Rwanda. I think that was it, actually. If you like to follow the case more closely, we produce a podcast, London War Crimes Trial podcast. You can see if you can. It's available through unpaiddebt.org, and I think also on Spotify. That's it.
Thank you so much, Eva. And I'm also going to do a plug about that podcast because it's brilliant, and I've listened to every episode, and I think it's incredibly informative, particularly for those of you that want to follow along on that case. So we've got some time now, really, for questions. There are a couple of questions. I've got one of the questions in the chat now, but I would encourage you all to ask any of the questions, whether you think they are easy or more difficult. We're hoping that this can be a space where you can explore some of the more technical elements of this issue. So the first question we've got is, how would you describe the status quo on reparations owed to victims of corporate complicity in international crimes? They've asked, would you argue that reparations, if themselves tied to asset forfeiture measures, could constitute a sufficient deterrent to corporate involvement in international crimes? Wayne, are you happy to take this question?
Sure, I'll try. I mean, it's a bit difficult to answer in one sense, in that, you know, looking into the minds of corporate actors who are not conducting heightened due diligence and are contributing to international crimes, and therefore may find themselves in front of a court with reparations, and what would deter them, and what would encourage them to conduct proper heightened due diligence. I mean, I guess the first thing I would say is reparations can take many forms. They can be, of course, material in the sense of monetary reparations paid for by the perpetrator of the crime. But they can also take, especially in international criminal situations, more symbolic forms, whether apologies, memorials, social reparations, which, for example, the International Criminal Court tends towards these days, which is to provide collective reparations for communities, to allow communities who've been affected by the crimes which have been tried to benefit from monetary reparations in the form of community activities. What would deter business actors is a very difficult question to answer. You know, there are many contributions made by businesses to international crimes, whether that's because of corporate culture, or whether that's because of just a disregard of heightened due diligence, or whether that's because businesses just, or some businesses just don't care about the damage done. It's a very difficult question to answer. It's also a very mixed picture out there. You know, we in Beyond work with corporates who care very deeply about their contributions to international crimes and avoiding them. And of course, we work with corporations who care less than that. So what seems to motivate corporations that we work with is a combination of social license to operate, all the way to some corporates who genuinely care about not just respecting human rights in conflict-affected areas, but also promoting human rights and being value add in very complex situations of international crime. So I know I'm rambling a bit because I don't really have an answer as to whether reparations, when combined with asset forfeit measures, would be sufficient. What I can also say, and just the last thing I'll say on this subject, is for the first time, we are going to have very shortly mandatory regional regulation, such as the CSDDD in Europe, with the ability of the independent regulators to be able to impose penalties and place those affected by corporate activities into compensation for any harm done, restitution for harm done, and those penalties can be up to 10% of the turnover of the companies caught within that act. So we are moving to a situation where there is much more mandatory regulation, where the penalties are going to be much harsher. And what we see and beyond is really quite some anxiety amongst companies as to the size of these potential penalties. So if I have to come down on one side or the other, whether reparations plus asset forfeiture could deter, it certainly could help deter.
That's really useful. Thank you. And actually goes to one of the questions that has been asked in the meantime about the potential for those mandatory human rights due diligence laws to prevent complicity of businesses in international crimes. Is there anything else that you wanted to add to that?
Well, I think the CS-DDD, but also others such as EUDR, these are really quite challenging pieces of legislation for companies. For the first time, at least those operating in or from Europe will have to really focus in on tracing back to source with proper rigorous due diligence, with real remediation when harm is identified. And I think, as I said, I think many corporations are busily trying to get ready for these pieces of legislation, and many are really anxious about whether they can be ready in time. Hence, for example, why the EUDR, the deforestation regulation, has been postponed for a year. And there's all sorts of activity which go towards trying to either remove some of the more challenging aspects of CS-DDD, or even postpone it completely, or get rid of it. And I think that speaks to the fact that companies not only find it challenging, but also are anxious of being caught within its terms and having to pay significant, not just fines, penalties, but also have to spend quite significant sums and time and resources in actually on a day-to-day ensuring their business activities don't fall foul of the law. So I think these pieces of legislation will be truly transformative of business activities, and therefore truly transformative of the communities that they operate in.
That's great, thank you. And we've got another question in particularly about the role of financial institutions, and then I'll turn to you, Eva, about a very particular question about the London case. But Wayne, we've been asked to what extent can financial institutions such as banks, as a party potentially even further removed from the crime, be held accountable for assisting parties that aid the facilitation of the international crime? And the person posing this question has also put in some context in consideration of the Lafarge judgment on corporate international criminal liability, namely that it suffices if the accomplice has knowledge that the principal perpetrators are committing a crime against humanity, and that by their aid or assistance, they facilitate its preparation or commission.
So as I understand, then the essence of the question is whether, if you are a bit more remote, i.e. you're an investor in a particular business activity, you could be held responsible under complicity, such as aiding and abetting.
Indeed, yes.
I would say the simple answer is yes, in the sense, and I think the person who asked the question identifies why. And I think, I mentioned there's essentially three forms of complicity. I mean, don't hold me strictly to that, because there's variations within the three, but the first is the intent complicity, where the individual needs to be shown to have intended the crime. That's the ICC. And then the second is where you need a substantial contribution, but combined only with an awareness that the contributing is assisting the crime. And then the third, and this is what Eva touched on with the London case, the problems that the London accused have, I think, is that the form of complicity requires, and Eva knows this better than I, but requires not contribution, which is one of the demanding thresholds, which makes it difficult sometimes to prove complicity, nor does it require anything approaching a strong intent element. Usually there's one or the other. You know, there's either the intent, the mental state, or there's the substantial contribution, and these two elements do the heavy lifting for modes of liability, such as aiding and abetting. However, at the national level, such as in Sweden, you don't need either. And so what you're looking at is a form of intent which is much more akin to recklessness or negligence than it is to any form of intent. So simple answer with investors, I mean, the starting point would be to, I guess, say, well, it depends where the consideration of liability is being had. Is it being had in somewhere like Sweden, or is it being had at somewhere like the International Criminal Court? Second would be they're not going to be first in the line for prosecution because they're more challenging cases, because the more remote the alleged actor is from the crimes, the harder it is to prosecute. So that's the second consideration. The third, I guess, would be that if you're an investor, your liability, according to the UN guiding principles, is much more about using your leverage on the business that you've lent money to or invested in to actually do the right thing. And that leverage will depend upon who the lender is, the size of the investment, who's been lent the money. And it will also depend upon the nature of the allegations. That might mean the investor has to demand, for example, that the recipient of their investment has to conduct a proper investigation. So they may be able to distance themselves even more from the complicity charge by taking steps to mitigate the harm and showing that they've taken those steps. But long way of saying there is nothing in principle to say they could not be responsible under complicity. It's difficult, but in some jurisdictions, it's easier than others.
Thank you. And indeed, we do have questions like this posed often by financial institutions in cases where these types of grave violations of human rights start occurring. So it's an interesting question. Just going to take 5 more minutes for those of you that can stay on to answer the last couple of questions. Eva, on the London case, do you know what extent or in what way international standards, and the person that posed this question is referring in particular to UNGPs, the UNDP guidance on heightened human rights due diligence and others, were referenced by the prosecutor in London? I appreciate that's quite a technical question, so if not, we can, I'm sure, come back in writing with an answer. But
well, I did a very quick Control F in the indictment, and short answer is no, which I think is the case because the crimes under consideration were late 1990s and early 2000s, which was before the UN Guiding Principles were published. That was 2011, I think. It is interesting, actually, that Lundin, well, since the publication of the UN Guiding Principles in their current policies, or from that time, do commit to the UNGPs and the OECD guidelines. And well, outside of the trial, we have always advocated, also in their AGMs, for them to actually live up to this commitment, because this is well, they should be assessing the impacts that they contributed to in Sudan. But they have always refused until today. But no, it's not part of the trial. It might, yeah, in my understanding, it might come up during the trial, but not in the indictment, I believe.
okay, that's useful. And as you said, there's still time. So I think the last question that we have is probably a question for you, Wayne, and just asking, in terms of international criminal law and international human rights law, is there a universal legal doctrine that establishes liability for a principal or corporate for the acts of its subcontractors? Again, a fairly technical question.
Yeah, I think there isn't a universal legal doctrine, is the simple answer. There's a variety of legal doctrines. I mean, this is part of the challenge, I think, of corporates acting globally. First of all, the principle of well, first of all, as I outlined, there's a variety of different domestic legislation. So much will very much depend upon where the charges are brought. And to this extent, I think, you know, the London accused are, in quotation marks, unlucky in that they are being tried in one of the most the lowest threshold national jurisdictions. So I think the first question for many corporates, well, actually, let me tip that on its head a bit. The first question for many human rights activists who are looking to take corporates to court is going to be, what's the best jurisdiction? What's the lowest threshold jurisdiction to try to persuade a national prosecutor, for example, under universal jurisdiction principles, which obliges states to investigate and prosecute international crimes wherever they occur. So the first question for human rights activists is, where can I bring this case where I can persuade a prosecutor in a national jurisdiction where the domestication of international criminal law provides the most the lowest threshold for conviction. I mean, that's the challenge, I think, for corporates, is to understand enough about where their involvement in international crimes might end up. It's not going to end up in an international criminal court, almost certainly not, because international criminal court cannot try corporates, although they can try individuals from corporates, but the International Criminal Court is overwhelmed with its bread and butter work, and corporate personnel are probably not yet falling into the bread and butter of International Criminal Court work. So it's much more, although it has to be said, the African Court of Human Rights has within its statute the ability to prosecute corporate actors, i.e. as legal persons. But the biggest risk for corporates is in the domestic level, and the system of prosecution, the nature of the crimes, the nature of the legal liability varies according to national legislation and how international criminal law has been domesticated. I hope that answers the question.
It does, thank you. So with that, we've got a number of people putting in suggestions into the chat, but I think we'll be bringing this webinar to a close now. I want to thank everybody for joining. I hope it's been informative. As we said, it's the first webinar in a series that we will be conducting across this year. The next one will be on the 6th of March, so again a Thursday, and we'll focus on the specifics of international humanitarian law, and there we will have the Australian Red Cross speaking. So we hope that you will all be able to make that session as well. And if you do have any suggestions for future sessions, we will be taking those. So anything practical that can help you in unpicking some of these issues, please do email us and we will be happy to integrate those into our schedule. Thank you, Eva, for joining us. Thank you, Wayne, and see you all next time. Thank you.
Thank you, everybody.